Hi folks, it's Rob Flux here from Property Developer Network, once again coming to you on a Sunday session. Drink in hand. This week it's actually a spiced honey bourbon, which I am going to savour for I guess the bulk of the hour. This week's session, we've actually had a couple of similar themes of late. So previously I've actually had a theme which was seeking out money partners. This week we're going to have the opposite side of the transaction, and that is how to actually be a money partner and what some of the issues and challenges that you're going to face along the way if you're wanting to invest in somebody else's deal. So I can see a couple of people coming online, but while we wait for the others to join us, I'm just going to do a tiny little bit of housekeeping. I guess want to firstly say a massive thank you to everyone who attended yesterday in Sydney, our meetup there, and especially Ian Ugarte, who I guess did a cameo guest appearance as our industry expert, and Davina Wong, who was actually the real deal. But we also had an information session in the morning with people inquiring about our property development formula program, and that was I guess quite well received, and a number of people very interested in that program. Upcoming events that we've got a meetup in Melbourne this weekend coming up. Once again, we'll be running that information session in the morning for anyone who's interested. That will be a free session. So that is on the 3rd of August. The 3rd of August, I should say. 3rd of August in the morning, and then in the afternoon, we're going to be running our normal meetup as per usual. So anyone who comes to the information session can come to the meetup in the afternoon for free, and otherwise we're looking to have a full house at that one. We're going to have Tony Meredith as the industry expert at that one. He's going to be talking about why most people fail at their goals. And we've also got a real deal being presented by Daniel Hayne with one of his recent projects. So I guess can see that Jason's reached out and said, hello, g'day mate, how are you? Deborah, Shelley, Brad, all on board as well. I can see there's a number of others whose names haven't jumped up. I can see that there's a number more people on there, but Facebook hasn't warned me of who is on board at this point in time. And Alex has just joined as well. So hi all. As I said, this week's session is how to be a money partner. I guess we'll encourage all of you to actually ask questions along the way. Not sure how many of you have either sought money partners before or are interested in being a money partner, but you need to understand both sides of the transaction. If you're trying to have a negotiation with someone, even if you're the one seeking the money partner, then you should understand what the money partner is actually looking for so that you can make sure that you're seeing their side of the equation, solve their problem, because they're actually helping you to solve yours. So if I look a little bit tired, guys, it's because it's been quite a big weekend. So I'm looking at my own eyes in the reflection, and they're looking quite bloodshot. It is just, it's not from anything ingested, I can assure you. It's just from having quite a big weekend in trying to get to this point in time. So being a money partner, what does that involve? Well, I guess there's a number of people in our community that are looking to do joint ventures, and they're looking, I guess, to, because they don't quite have all of the funds themselves. Sometimes they're seeking small amounts of money. Sometimes they're seeking someone to actually invest in, I guess, the entire project from start to finish. So there's a few different roles that a money partner can actually play. So let's start with the nice, simple roles, and then step up to some of the more complex ways that this can actually be done. So a very simple role might be that and I just saw Dave say, hi, hey mate, how are you? Listening on the drive home from soccer, fantastic. Hope you won, or not you won, but whoever was playing, but yes, hope it was a good result. I guess being let me rephrase that. Sorry, stumbling on my own words, trying to race through. I guess as I said, there's a couple of different roles you can play, but if you are actually running a deal and you are just short of a little bit of money, you may be wanting someone to just top up your funds. Okay, so when you've got someone to top up the funds, that person may typically come in the capacity of a loan. Okay, so in which case you will be lending money There are some legal requirements with regards to having private money outside of, I guess, the normal banking arrangement. You would need to have a formal loan document drawn up, firstly, and that formal loan document needs to be a business-to-business loan document. So it can't be an individual to a business. It can't be a business to an individual. It can't be an individual to an individual. It has to be a business-to-business loan. And the reason for that is it triggers a number of ASIC and APRA regulations if you don't do that. And so it's very important that you go seek legal advice to make sure that, I guess, you get these loans drawn up in the appropriate way, and that you have some form of entity, whether it be a company, whether it be a trust, whether it be a self-managed super fund, some sort of entity on both sides of the transaction. And that is very clearly stipulated in those loan documents. Now, the loan documents themselves, they're going to cover a number of common elements. So it's going to be how much money is being borrowed, what the interest rate is on the loan, what the security is that's going to be held, and I'm going to talk to security in a couple of moments, how and when the money is anticipated to be returned, and what the purpose of the money is actually for. In addition to that, you'd be then talking about what happens if the money is not returned, what penalty rates may or may not occur, and again, where there is security involved, I guess the process for that to be drawn, I guess for that security to be called in. So if we go through some of those elements, the security can take a number of forms. The security can take, I guess, the way of a first mortgage. It could take a second mortgage. It could take a third mortgage, sorry, not a third mortgage, a caveat, I should say, or it could be an unsecured loan, or it may have a personal guarantee. So they're I guess, the different ways of actually securing the loan. Now, the higher the level of security, then typically the lower the interest rate on the loan, because the surety of the lender getting their funds back are a lot greater, and the ability to call that in becomes a lot simpler. So if I go through those levels of security very basically, first mortgage means that that person, if they are not paid back, they have the right to actually call in the loan by selling the property down. And when they sell the property down, because they're the first mortgagee, they get the first round of funds that come back from the sale. And they're effectively going to be controlling that sales process should that occur. So that typically that's the role that your normal bank would play is being the first mortgagee. And so they always have the first right. But if it's private lending, then if that person is there, then they take that particular role. Now, because that person can call in the loan, that is, I guess, effectively the most secure level of security. So that would typically, I guess, bring about the lowest interest rate. Now, interest rates as a range, I'm going to talk about later, I guess, as a subtopic in itself. So if we just keep on the topic of security, and then I'll come back around to the interest rates. So from if that loan is called in, that first mortgagee being in control of the sales process, they're pretty much the one dictating how that sale actually occurs. And all they're really caring about is whether or not they get their funds back. And whether or not there's a second mortgagee or anything, I guess, behind that, they're not really concerned about typically. Now, if you have a conscience, you would try to make sure that everyone is accounted for. But I guess there's no legal obligation that they're actually going to do that. So I guess bear in mind that that may actually occur. If you are the second mortgagee, then obviously the first mortgagee has priority. And so you're at the mercy of the first mortgagee and the sales campaign that they actually run, and whether or not there is enough funds from the sale of that property, should it need to be called in, to pay down the first mortgagee first of all, and then trickle feed down whatever is left over to you as the second mortgagee. I can see a couple of other people coming on, so I'm just going to do a quick shout out. So I can see Margaret, Dave, Carol, Matt, Michael, Brenda, and Facebook's telling me there's 17, but I can't actually see all 17 at this moment in time. So if I haven't called your name out, I apologize. Again, because the second mortgagee is a little bit lower in that food chain, then typically their interest rates are going to be a little bit higher. Next down the food chain from a security perspective is going to be a caveat. Now, a caveat is a little bit different from I guess, being a first or second mortgage. And that is because anyone with a caveat can't actually force the sale of the property. What they can do, however, by lodging a caveat against the property, what they can do is stop the first mortgagee or the second mortgagee calling in the debt, because they're basically saying, well, there's I guess, a hold on the title, and that first and or second mortgagee needs to negotiate with the caveated person to allow that caveat to be lifted. Now, because you aren't in control of the sale, you can't force that sale to actually occur. It may take a long time before the property is actually sold before you are able to enforce that caveat. So it sits there indefinitely. Now, there's a couple of different kinds of caveats. I'll talk to those in a minute. But it sits there indefinitely dormant on the title unless and until somebody attempts to sell the property. And then the caveat needs to be resolved and lifted before the sale can actually take place and before the titles can actually, I guess, transfer between others. So from a control perspective, a caveat is obviously a little bit lower in the food chain because they can't enforce getting their money back and they may have to wait for quite some time. Now, when I say quite some time, if they choose to never sell the property, it could be 20 odd years that you're waiting to get those funds back. The caveat will still sit there. Now, there's a couple of different kinds of caveats. So I'm going to caveat the fact that there are different caveats by saying the normal form of a caveat is one that typically only hangs around on title for about 3 months. And so once you lodge that, I guess it sits on the title for about 3 months and then is automatically extinguished. And so that's not a heck of a lot of security. So if you are going to be asking for a caveat, then you need to have one that actually has the written consent of the property owner, which means that with the written consent plus the caveat, that can then sit on title indefinitely, unless and until it's actually lifted. Now, if you're putting a caveat on a property, then one of the conditions that will typically be sitting in the loan document is the fact that that caveat must be lifted prior to settlement in order for the property to transact, in order for the funds to come through, in order for you to actually get paid. So there's going to be a little bit of a process where you lift it so that they can sell the property and cash come in. During that period of time, there's a very small window of risk where you have no control or security over the property. But if you've appropriately documented it and it's going through solicitors, then those funds would be put in the trust account, and you would have negotiated that the funds in the trust account must be released to yourself. And so the solicitors have an obligation to make sure that that is actually dealt with appropriately. So make sure that, I guess, if you're going down the path of a caveat, that you have firstly, you have the documentation up front to make sure that you have a caveat with consent. And secondly, when you go to release the caveat, that you have instructed the solicitors on both sides that the funds that are held in trust, some of those must be reserved for you and distributed to you to, I guess, extinguish the debt that is sitting there. I can see a number of others that have jumped on. So rather than naming everybody, I'm just going to say hi. Encourage questions as we go, folks. So I guess whilst I wait for a couple of questions to come through, I'm just going to take a tiny sip. I guess the next level of security would be a personal guarantee. Now, personal guarantee means that you don't actually have any guarantee against any individual asset, but rather that you've got I guess, effectively a promissory note from the individual who has signed that personal guarantee that across all of their assets, they have enough assets or equity to be able to refund that debt. Now, in order to claim that, it may actually take legal proceedings to, I guess, pursue which individual asset is going to be sold down in order to, I guess, reclaim the outstanding funds. And remembering that whatever asset you go to choose, let's just say that they have a principal place of residence, then chances are they've already got a loan with somebody else. That loan would already have a first mortgage, so that first mortgagee still stands in front of you. So a personal guarantee is, I guess, still enables you to pursue the debt, but it makes it a lot more challenging in the process, a lot more, I guess, legally challenging, and secondary, that you need to make sure that the asset that you choose to try and get relinquished firstly has enough equity in it to release the first mortgagee and or second mortgagee that's sitting there in order to pursue some funds down the bottom. Can see a couple of others, and good long-time friends, Karen and Dave, have jumped on. Hi, guys. We are way overdue for catching up, folks. So I'm going to make it a mission at the end of this session to actually give you a call. Annie's got a question. Lenders, in brackets, senior lenders, don't really like caveats, do they? And if a caveat is lodged, lenders will be notified, don't they? So to answer your question, there's a couple of questions sitting in there, Annie. So the answer is no, they don't like caveats. However, they can't stop a caveat from being lodged, and they equally don't get notified automatically. They may, if they have a reason to do a title search, become aware of that, but typically they don't do title searches for no reason whatsoever. They generally have an alert in some way, shape or form where you've done something somewhere else, and they go, well, it's time to trigger a review of your proceedings. So for example, if you've got a fixed term loan and that fixed term comes up and then they're going to reassess your portfolio, it's typically going to come up in those ways of the way that they would find out, as opposed to getting a notification when the caveat is actually lodged, which does not occur. So hopefully that actually helps you. The reason why those lenders don't like that is because they must negotiate with the person who owns the caveat in order to, I guess, come to a resolution to have that caveat lifted before they can actually enforce the sale of the property. So hopefully that helps to answer that, Annie. Can also see that Dean's joined and Marcus has joined. So hi, folks, how are you? So hopefully that helps from I guess a private loan and a private lending type situation. Make sure you've actually got that legally documented, as I said, company to company transaction. You've got those securities actually listed in place. You know what your interest rate is, you know when the repayment is, you know what the penalty clauses are, and you know what your securities are. So they're I guess, one way as an investor you can actually invest in somebody's loan, in somebody's project. The other way to invest in somebody's project is to go in as I guess, a formal joint venture money partner, and that can take a number of different forms. So in doing that and in coming in a number of different forms, there's a couple of extra elements that you may want to be considering in that regard. So you would again have a legal document that's drawn up. In this instance, it doesn't legally have to be a company to company. It can be, I guess, any arrangement from that perspective. You're effectively going in as whatever entity that you need to as the money partner. The challenge will be that if you're going into that, if you've got cash and you're paying for the entire project in cash, then many of your problems that I'm going to talk about in a moment won't come to fruition. So if you're a very cashed up money partner and paying cash for a project, then some of what I'm going to say doesn't apply. However, if you are somebody who has a lot of liquidity and you're going to be a serviceability partner and you have to in turn go out to a bank in order to get a loan for the property, then there's going to be a couple of elements that you need to be cognizant of in the process. I can see a couple of people commenting. So Marcus has said hi, say g'day mate. Adam's also joined, and Annie said good answer, thanks. No problem at all, Annie. So let's just deal firstly as a money partner with all the cash, okay? Then after that, I'll talk about, I guess, a joint venture money partner where they may have to actually go get some secondary borrowings from a bank. So if we're talking about a pure cash joint venture money partner person here, then you would make sure that firstly you've got a joint venture document that actually highlights everybody's roles and responsibilities. It's going to highlight I guess, what will happen if you've got disagreements in the process, and what is the process that you're going to do in order to go to mediation, who's going to be the adjudicator on all of those things. So should something actually occur, you also want to make sure that you've got exit strategies already clearly defined, and I'm going to say multiple exit strategies. So everybody going into the project should have the same, I guess, final goal as the desired outcome. But you should also have a number of secondary exit strategies that you've already got defined, because circumstances change. And it's not always the fact that something happens within the project, but it could be that as the money partner, you get sick. It could be as a money partner that that somebody else in the family gets sick and you need to fund some medical expenses. It could be that you lose your job and all of a sudden cash flow and serviceability becomes challenging. So you should always document multiple exit strategies that can account for the fact that the project may not go all the way through to completion, and that there are going to be events that may trigger the fact that as a money partner, you're going to say, hey, I can't take this through to the end. Now, in that case, with having multiple exit strategies predefined, you would then find the next safest exit point that and try to manage the project to the point where it is a nice, clean exit out of the deal. For example, you may say that you're going to exit the property at development approval stage rather than all the way at the end of construct. So if they've lodged the DA and you come into some financial difficulties, then you may say, well, okay, we'll wait that period of time until that development approval comes back. That's going to give us the uplift we need to actually justify the expenses that we've paid, and that's going to be the nice, clean way to actually exit that. So you want to make sure that you've got some steps in that. So the most logical steps that come to mind that are going to apply in most instances would be where you've got development approval, where you may have operational works approval, where you've actually executed the DA and I guess separated titles if you're doing a subdivision. It may also be if you're going to do a construction, whether or not you've actually got building approval, whether you've got pre-sales, a certain number of pre-sales in order to get finance approved. So there's a number of steps that you can actually highlight, but there could be some individual personal ones depending upon your individual project. Some other elements that you would try to have in that roles and in that joint venture document, I should say, would be who is actually going to be on title. Okay, the person who has funded the deal, or is it going to be the person who is running the deal, or is it going to be both of you? That becomes quite critical because the person on title has the ultimate ownership of the project. And what I mean by that is that irrespective of the fact that you may have signed up to a joint venture time partner who's going to run the deal, you may have said they have all of the control to make all of the decisions. But if you're the one on title, when they go to sell the property, if you refuse to sign the sales contract, then you basically tie them up in a knot, and you can and will potentially jeopardize the outcome of a project. I personally have been in the unfortunate instance where somebody else was actually in control of that process because they were on title, and it ended up costing nearly $140,000 in lost revenue because they didn't know how to appropriately manage that sales cycle. And I guess without going into the details of the project and I guess the circumstances behind that, but it meant that despite that I had a legal document that was nearly 40 pages thick saying that I was in control, because I had no legal authority to actually sign for the sale, it meant that the ultimate control lay with somebody else, and it would have taken quite a lot of legal arguing to change that outcome. Now, I was quite fortunate that despite the fact that we lost some revenue out of that process, we actually were still quite profitable in the deal. It's just that we could have been a heck of a lot more profitable if they had have allowed that sales campaign to actually be to run the way it could have and should have been. So some other elements to think about if you're, I guess, funding a project in a cash type arrangement. I guess I've mentioned roles and responsibilities, but you want to be very clear on who is performing what roles. So is it the time partner that physically pays the bills, and as the money partner, you put money into a bank account? Or as the money partner, are you going to be the one responsible for the bills, in which case you're going to control that process all the way through to the end? So if it's the former, then you're going to have some sort of process to say, well, justify the fact that you've got an invoice, justify where it's going to, and you may need to sign it off. Or equally, you may have a joint bank account where one person loads up the invoice ready to be paid, and the other person goes in and countersigns that as an approval to go through. So a number of different things that you can actually do along the way. So Trent says mortgages fixes that. So Trent, not sure which particular point that you're referencing, but yes, mortgages absolutely allow some of that to be controlled. You're correct. So you have the ability to call in the loan if that's the case, but if you're trying to actually go through the sales campaign, then I guess there's a couple of elements there that don't allow 100% of that. So then the other side of things would be if you're not a 100% money partner from a cash perspective, if you're a money partner who may have a small amount of equity that you're putting in, and then you actually then go to a bank as the primary lender, then the bank as the primary lender will then have first mortgage over the process. And so you as the secondary need to actually understand what security you're going to have sitting behind that. And typically that's going to be a second mortgage type situation. Where that gets messy is that the project manager trying to run the deal, that person is then going to have some challenges as to whether or not they're actually on title. Because if they're on title, and depending upon how they're on title, then the bank may actually want them to be also personal guarantees in the loan. And if that's the case, depending upon the number of projects they've got running at the time, that can actually complicate the loan process in that regard. So a couple of different elements to think about in that regard. Couple of ways that can actually be dealt with. Typically, you would be going in with a special purpose vehicle entity that is actually doing the project. And if you're doing a pure joint venture, then the person who is the money partner may be initially the sole director in order to get the finance, and then the project manager would be added as a director later in the process. So that's one way of actually dealing with that. There's also, I guess, a number of other ways that you can actually be doing things where you might be going in a syndicated type fashion. So if you're going in a syndicated type fashion, then there are a number of different people with small amounts of money that are all wanting security, but it's very difficult for them to each have a first mortgage, second mortgage, caveat, etc. So instead, there would typically be an investment vehicle set up as a special purpose vehicle for those purposes. The investors would pool their money into that investment vehicle, and the investment vehicle would then be the one that actually has the security over the project. That can be done in a couple of different ways. The investment vehicle may potentially be a company, and the number of shares actually allocated in proportion to the ratio that I guess the ownership is. So if you've put 200K in, the next person's put 400K in, then you'd have shares apportioned in appropriate manners in that regard. Annie says, can you explain SPV? So special purpose vehicle. Annie, it's an entity that is set up, and they can take a number of different forms, but typically it's going to be a company or it could be a company trust arrangement, but it's set up for the sole purpose of doing that one transaction. And at the end of that one transaction, it is collapsed down. Any assets and liabilities are, I guess, passed back to their appropriate holders. It does a tax return if and where it's required, and then it gets collapsed down and everybody goes their own separate ways. So that's what a special purpose vehicle is for. And when do you need one? From an asset protection perspective, I would highly recommend that every single development is actually done in its own special purpose vehicle. If you do that in that regard, it means that once that project is actually finished, you can collapse that entity down. any ongoing liabilities that may sit behind the scenes on that. So if you've done a construct, there may be some construction liabilities that sit there for some time. That would disappear, and the ultimate purchaser of the finished product would still be protected by their homeowner's warranty insurance. So you're basically taking yourself out of the loop. So if you look at the food chain, when the ultimate buyer buys the finished product, they would typically go directly to the developer. I guess in the first instance, if something goes wrong, the developer then goes to the builder, and so if the developer doesn't exist, the ultimate buyer goes directly to the builder. If the builder doesn't exist, then they make a claim against their homeowner's warranty insurance. So hopefully that helps in that regard. Just going to take a small sip, getting quite parched here. So guys, I encourage any questions to come through as we go. There's always a little bit of a lag between the question being asked and the response coming in. Excuse me, I got a bit of a tickle in my throat. Been talking all day yesterday at our Sydney session, so just trying to recover from that a little bit. I can see Corin has also joined, so welcome, mate. Annie says, correct me if I'm wrong, an SPV can't be a company then, it needs to be a trust since it closes down at the end. No, that's not quite right, Annie. A special purpose vehicle can be any entity. It can be a company, it can be a trust, it can be a company as trustee for a trust, it can be a joint venture arrangement. There's a number of different combinations that can actually go into that. That's really going to come down to recommendations from your accountant and your solicitor in regards to, I guess, what you are trying to achieve and which particular entity is the right way to actually do it. SPV is really just a generic term that says it's really set up just for the purposes of that one individual transaction. I would say the most common form of SPV happens to be a company, but that is not the only way that it can actually be done. Obviously, you're going to caveat the heck out of all of this to say, I'm not a solicitor, I'm equally not an accountant, and you need to be talking to each of those specialists to make sure that it actually suits your circumstance. But SPV just means just for the purpose of that one transaction. Trying to think what other combinations of money partner may actually be investing. So if you're trying to invest in someone else's deal, the one thing that I would say as a money partner, irrespective of who the person is that you're investing in, the outcome of the project, you as a money partner are just as responsible for what your money does as the person who's actually running the deal. And what I mean by that is you need to be, I guess, in a position where you can actually ascertain the level of risk that's actually contained within the project itself. You need to be able to do, I guess, a fair amount of due diligence to make sure that what has been presented to you as the deal is actually true and factually correct. Generally, the person who's running the deal is going to give you some form of information memorandum that's going to tell you a little bit about the project, a little bit about the anticipated returns, how the project's going to be run, what the timelines are, what the exits are. But you need to be able to put a critical eye over that document. You need to be able to understand that what it is that you're putting your money into is actually a fair and reasonable outcome. There are a number of times where things do go wrong, okay? Not every project runs 100% smoothly. So you need to be understanding of what some of those risks are, what some of those challenges are, be cognizant of that, be able to ask the appropriate questions of the person that you're investing into, and make sure that they are, I guess, have the appropriate level of experience, that they've got the appropriate asset protection behind them, that you've got the appropriate security behind them, and that the information in that information memorandum is true and factually correct. You equally should be, I guess, mindful as yourself, if you're investing in someone else's deal, it needs to be money that you can afford to lose should the project go wrong. Now, heaven forbid, none of us want a project to go wrong. It's certainly we don't go into it with that intended outcome, but you shouldn't be putting all of your life savings into something. And if it does go wrong for something outside of the control of either the developer or yourself, sometimes there are circumstances that occur, GFC, for example, that are beyond everybody's, I guess, intended outcome. you need to be in a position to actually be able to deal with that hurt should that actually occur. So we've actually had some real deals presented in our group over time where the money partner that was in the deal has actually presented from their perspective as to how things have actually gone wrong. And I highly encourage you to actually go and have a look at some of those and some of the recommendations that came out of that as a money partner, you should be just as invested in the outcome as the person running the deal. Make sure you do your due diligence on the person running the project, that you've done reference checks to make sure that they're I guess running deals appropriately, that the people that have invested with them before have got the outcomes that they're anticipating, how they actually deal with issues and challenges, etc., etc. So Cherry has asked, hi Rob, I have a question that's irrelevant to this topic. My friend's development site has been dumped a huge amount of rubbish that she now has to spend more than $1 million to remove the rubbish. There were no cameras on the street, and so it all cannot track. So Cherry, I'm going to say, I guess the entire intent of these Sunday sessions is to try and stick to an individual topic. I'm happy to see what I can do offline on that, but I guess because we've got, I guess, a number of other people on this call that are very specifically here for this topic, at this point in time, it's probably not appropriate for me to respond to that, but more than happy to have a chat with you off air if you want to try and give me a call on Monday. I think I've kind of covered, I guess, a number of the generic bases that you could be considering to do as a money partner, or I guess somebody investing money. I guess if I recap on those, you could be doing, I guess, a basic lend. You could be going in as a pure joint venture money partner where you're paying all of the cash into the process and you've got formal joint venture documents in place. You could equally be doing a joint venture where you are, I guess, both funding the deal, but also being serviceability partner and going out and getting a primary loan out of that respect. And you could also be going in a small fashion in through a syndicated type fashion. Now, with regards to the syndicated one that's just come to mind, be very cognizant of this, that depending upon how you've been approached for that syndicated funding, that the person who has sought the funds from you, so this is not you yourself personally liable as the investor, but the person who's sought the funds from you may have some obligations through ASIC with regards to whether or not they need to have an AFSL license for how they've actually gone and sought those funds. So make sure that you at least ask that question as to whether or not that should be applicable. In many instances, I guess the person running the project, if that is going to trigger that, they will typically go through a third party who actually has that AFSL license, and they will actually do, I guess, the work underneath the covers to make sure that is a compliant process. But there's a mechanism within ASIC which is called the 2012-2 rule, or sorry, not called that, it's often referenced as that. So no more than 20 investors have been approached, no more than $2 million has been raised within any 12-month period. So that 2012-2 rule can actually be triggered accidentally. Those 20 investors are what they call, I guess, minor investors. If you are a sophisticated investor, there's some criteria that sit around that to determine if you're a sophisticated investor, then you don't trigger one of the count towards the 20. So that's generally not your concern as the money partner, but it is something that you should be asking, I guess, the person seeking the funds to make sure that they're actually doing the right thing. Because the last thing that you want to happen is somebody like ASIC coming in and, I guess, calling in the project saying, well, that's been done illegally, and then taking over. I've not heard of that occurring, but it's just something to be mindful of in the process. So Cherry says, understood, thanks, Rob. Annie says, as a money partner, do we need to consider if the development project has insurance in place? What kind of insurance should be in place? So absolutely, Annie, there's a number of different layers of insurance. I guess the individual consultants need to be insured. The person who is the time partner needs to be insured. They need to have both public liability and private indemnity insurance. And any builder that they're going to be engaging also needs to be insured. generally, the builder is going to have their own public liability and personal indemnity insurance, and they're also going to have a compulsory homeowner's warranty insurance through the relevant state building authority. So yes, they should all be in place, and that's part of the due diligence that you should be putting in. So great question, Annie. Mindful of the fact that we're coming up to 40 odd minutes, folks. So I'll do a quick reach out to say, if you've got any questions, now's the time to actually ask before we wrap this up. There is a small lag between a question being asked and me actually being able to see it. So please make sure that you, I guess, throw those questions out now. What about crowdfunding? Have to go to training, so we'll hopefully catch the answer on replay. Okay, understand, Deborah. So crowdfunding is a very interesting model. So the challenge that we've got here is it triggers a couple of elements. And I mentioned that 2012-2 rule, Deborah. So that can be triggered through crowdfunding because you're likely to be triggering more than 20 people in the process. That can be gotten around by a number of different ways. One is that somebody who is AFSL licensed has actually, I guess, put together the appropriate product disclosure statement to actually define that and gone through the appropriate mechanisms to have ASIC actually anoint the fund. That's one way. Another way is that the person doing the project, instead of being a company that is a proprietary limited, they are a limited company. So it won't be proprietary limited, it would just be limited. So when you're a limited company, then some slightly different rules start to trigger, and that will typically avoid some of that. Now, that's not my personal area of expertise, so I can't speak with a huge amount of authority on that, but you, from time to time, will see a number of people who do raise funds through crowdfunding. There's a couple of platforms out there that put together I guess, a way of developers actually doing that, and they put those structures together in the back end to actually allow that to happen without naming who those suppliers are. But there's a couple that are relatively well known within the industry that actually go and actually do all the compliance side of things. So the developer would go to them, get all the compliance actually set up. That person would then be the person who, I guess, facilitates and collects the funds on behalf of the developer, and they take a small margin for, I guess, the privilege of doing that and managing that process. So I can see that Ivan has joined and Pat has also joined. So folks, we're right at the tail end of this. So appreciate that you've come on board. I can see Paul also came on fairly late in the process. So we're pretty much wrapping up at this point in time. So if you have any last questions, now's the time to ask them. Otherwise, I'm pretty much going to call it quits. And so please go back and replay this and watch it from start to finish. So whilst I just wait for any last comments to come through, I'll just do a little bit of housekeeping again. Our next Property Developer Network will be actually run in Melbourne. We've got our normal monthly meetup there that we have on the first Saturday of every month. So that's going to be the case there. I've got my good friend Tony Meredith going to be presenting on why most people fail their goals, and also a real deal by Daniel Hain. So that's the afternoon session. We also have a special, I guess, we only run these twice a year, but it's an information session on how to get into property development. If anyone is interested at all in our 12-month program, then we're running a morning session on how to do that. It's a 3-hour session. Anyone who comes to that will come to the afternoon session for free. So that being the case, folks, and as I can't see any more questions coming in, I'm going to say thank you very much for joining us, and I will catch you again next week on the next Sunday session. Until then, bye for now, folks. Ciao.